What the stand your ground law does is keep the innocent citizen who's telling the truth that they did shoot in self-defense from going through the kind of legal nightmare that Clayton Kramer just described to you. I've been an expert witness for the courts in shooting cases and weapons cases since the year 1979. I can point to people who, by the time they were finally acquitted, had paid 6 figures in legal fees. People who've lost their jobs, and we'll talk in a minute more, it goes beyond the financial. You'll hear the argument, well, we shouldn't allow stand your ground because it makes the police's job more difficult and it makes the prosecutors more difficult. I submit to you that that is not true. The burden that the prosecution has is to show that you are guilty beyond a reasonable doubt, a likelihood in the high 90th percentile. For you to get off on presumption of reasonableness, you have to show to a greater than the not certainty level, preponderance of evidence, 51%, 50.1%, whatever the given law professor may quantify it as, that you did the right thing. Do the math. If you have been able to convince a judge at hearing that it's more than 50% likely you're telling the truth and you acted in lawful, justified self-defense, how on earth is any honest prosecutor who ever lived going to turn that around in a convincing the same impartial judge or jury that, nah, he's 98% likely that he did wrong instead of right? In essence, it's not going to change anything. If anything, it may literally be more cost-effective and more efficient, as well as simply more just for the legal system. If within a matter of weeks after charging, a hearing determines that, yep, more likely than not, this guy really did shoot in self-defense, and that's what the evidence shows, it's done. We've preserved our fiduciary duty to the taxpayers not to squander their money in a trial that could last for weeks or even months, in a world where it costs thousands of dollars a day to keep that courtroom open, where it costs hundreds of dollars an hour for you, the defendant, to pay for your defense attorney. We hear people say, well, this law says you can shoot anybody if you feel the least bit scared of them. Anyone who tells you that has told you they never read the law. Google that statute. Look in any of the states, and these are the majority of the states, as Clayton told you, that have the stand your ground principle. It doesn't say you can shoot because you're scared, because you're nervous, because you had mere suspicion. You'll have to show that your action was reasonable. Now, what you want to do in the Florida statute says reasonable. It doesn't show you how to find reasonable. So you do a Google search for the Florida jury instructions, and you'll find out that just like every other jurisdiction in the country, they use another English common law doctrine called the Doctrine of the Reasonable Person. That's essentially a 3-pronged test. The trier of the facts must ask themselves, what would a reasonable and prudent person have done in the exact same situation as this defendant, knowing what this defendant knew under the circumstances? So if anyone tells you, gee, this law says if somebody looks at you cross-eyed, you can shoot them, they're telling you they never read the law. They're telling you they don't understand the concept. Basically, this has not been a huge sea change, as Clayton explained. Even in the states that still have the so-called retreat requirement, again, we need to read the fine print. Nowhere in this country has retreat ever been demanded unless it could be accomplished with complete safety to oneself and to others. Those others being those within the defendant's mantle of protection, their family, their customers, in a robbery of the store that they owned, something of that nature. We've got, what, about 100 people in here? Let me ask you a question that I've been asking my students for many years. Can any of you think of a situation where you would shoot a human being to death if you could have simply walked away and retreated in complete safety to oneself and others, without trying to outrun a bullet, without trying to turn your back on a drawn knife, without trying to walk backward faster than another human being can walk forward? I see no hands. Don't feel bad. No one else has ever been able to answer that question for me either. It's not a change in how things are done. We're allowed in this country to use lethal force to defend ourselves, our families, our loved ones. When we're in situations of immediate, otherwise unavoidable danger of death or great bodily harm to ourselves or to others within that mantle of our protection. Historically, it's been a three-pronged test to determine whether that situation existed. And different jurisdictions, different police academies, different training schools will use different terminology. But basically, the three factors are most commonly known as ability, opportunity, and jeopardy. Ability means your opponent has the power to exert deadly force, that is, to inflict a fatal injury or a crippling injury. Often that will take the form of a per se weapon, the knife, the club, the pistol. It can also take the form of disparity of force. Disparity of force is a category of situations where the unarmed attacker has such a physical advantage that he's so likely to kill or cripple the armed person that that advantage becomes the equivalent of a deadly weapon and allows his intended victim to respond with deadly force. We can see examples in this room. Anyone in here with a physical handicap attacked by an able-bodied person is facing disparity of force, and in a true violent attack is authorized to use a deadly weapon in self-defense. As a general rule, the female attacked by the male, because society recognizes males tend to be larger, have greater upper body strength, and have been acculturated to be more aggressive. We spoke of the physical handicap. That can also be a handicap that occurs in the course of the fight. You're an able-bodied man in prime of life, but in the course of the fight, the other man has been able to break your kneecap. Now you can't move away from him. Now you can't fight back on an equal force level. At this point, we've reached deadly force level for you to respond with. It could be something as simple as position of advantage. The two of you are exactly the same height, weight, physical skill. But the other man manages to get you down and he's banging your head against a rock. Or the other man gets you down and he's stomping you. A kick that before might have broken a rib, when you're down on the ground, now becomes lethal force. Because if you've ever read in certain law books that are laws of states that a shod foot is a deadly weapon, doesn't mean a guy kicking you in the butt. It means if you're down and being stomped. If my colleague on the left throws a punch at me here, I can slip the punch, I can roll with the punch, but if he gets me down, I can't do either of those things. And now my head here is caught between the underlying ground and the crushing force of his whole body weight. And in that situation, his position of advantage becomes the same as a deadly weapon and would authorize me to draw my gun or knife in self-defense. Force of numbers is an extremely common example of disparity of force. The single individual attacked by 2 people, 3 people, 4. So that would be the ability element. The opportunity element means capable of immediately employing that power. If someone up there in the back row was threatening to stab me, I'd certainly be concerned about it, but he has a great distance to travel. He has to get past several rows of seats, and he has to get past several people who, at least one of whom I hope, would stop him from stabbing the poor little old man. But if instead he's up here with us, nothing in between us, the tests have shown since the pioneering work of Dennis Tueller in 1983, the average adult male from a standing start can close a distance of more than 20 feet and stab their victim in an average time of 1.5 seconds. So in that situation, the opportunity factor would be in. And finally, the third element, jeopardy. Jeopardy means his words and or actions manifest an intent to cause death or great bodily harm as it would be interpreted by any reasonable and prudent person such as yourself. When those 3 things come together, deadly force is warranted in self-defense. It happens very frequently in this country. The stand your ground laws were promoted by the people who recognize that and by the people who have seen the ironic tragedy of someone who defends themselves, defends their family, preserves themselves from a murderous attack to come home to their loved ones, suddenly having to go through the ordeal, both criminal and civil, of being painted as the murderer, as the reckless slaughterer of men. Let me close briefly because I don't want to take too much time here. We're not talking ancient history. We're talking things that have happened recently. Case in point, in West Des Moines, Iowa, October 29th of last year. A man named Jay Lewis, middle-aged guy, federal employee, works in an office, clean criminal record, so clean he has a license to carry a concealed handgun in public, is attacked on the street by two men of another color. They decide it would be an excellent idea to physically assault him. He draws his gun. He orders them vehemently to stay back. They lunge. Disparity of force is in play. He fires. One man is shot across the pectoral muscle into the bicep and wounded, and the two of them decide, you know what? It's not fun being two coyotes on a bunny when the bunny shoots back. We're leaving now. Does anybody have a problem with that act of self-defense? Jay Lewis, the man who fired, was African American. His two attackers, including the one who was wounded, was Caucasian. The topic of race as it affects criminal justice in America is the topic for another day, at least for me. Jay Lewis was arrested. Jay Lewis was held on a six-figure bond that on an ordinary working man's salary he could not afford. He stayed there rotting in jail. Meanwhile, the folks who owned the apartment building where he lived served a notice that said, ooh, we understand you've just been arrested for shooting someone. You are altogether too scary and dangerous to live among us. Consider yourself evicted. And they mailed it to him at his apartment address and posted it on his door at his apartment when they knew or should have known that he was in jail and could not receive them. And when he did not respond to that after the 30 days or whatever, they cleaned out his apartment, put his furniture, his clothing, his computers, including a novel he was writing, out on the front lawn to be stolen by whoever came by, and of course they all were. And after 112 days in jail, the prosecution dropped the majority of charges, took him to trial on the rest, and the jury said collectively, are you kidding us? And rendered the acquittal. Does that mean the system works? To an extent it does. The man was literally homeless, damn near penniless. That's not the way justice should work. It was to prevent things like that that political activists, civil rights activists, and I consider, we have many levels of civil rights activists in here. Those who fight for gun owners' rights I consider to be civil rights activists as well. I remember that Charlton Heston, former president of the NRA, marched with Martin Luther King, who was also a gun owner. But their efforts have given us the stand your ground laws in many states. They are moving now to put that law in place in the state of Iowa to prevent the kind of injustice that Jay Lewis suffered from being suffered by any of their citizens there. And for that reason, this speaker supports the concept. Thank you.